Everybody raise their hand. Okay.
There's no way.
And why is it important to you? Wrong. It was not called diets. No, anybody else want to raise their hand?
Debt, income, mortgage, education. Minus insurance in place equals your shortfall.
She get paid today. Anybody else want to tell you anything else? Okay, so we're gonna get started with prayer.
That's me. You're doing prayer? No. Oh, come on. That's up there.
Every one of us up this morning, we're going to pray and thank Him for that. Lord, we thank you, Father God, that you were gracious and woke us up this morning and in our right minds, Father God. And we thank you, oh God, for protecting us as we drove here this morning. Thank you so much, and bless our health and bless the sessions and information that is going to be given to us today, and bless anyone else that's on their way. Amen.
Okay, so our first speaker today, everybody knows this lady. She is an educator in Pomona Unified School District. And she actually does our announcements at our church. What does she do, Linda? She does a lot.
Good morning, good morning, good morning. We are gonna go ahead and talk about what the homework we had last night, not last night, last Saturday. Cause y'all took the sheet home, right? And you didn't put it away and not do anything with it, right? So who did something with this sheet? Be honest. See Katie? Nobody else. Okay, Rhonda? Filled it in. No, not the survey, that sheet that says. So where's that? Yeah, you did, this is part 2. No, we don't, it's part 2. Today is part 2. So, I think we have extras. Okay, look in your folder from today, the old people, did they bring your folder? Okay, I need who needs a sheet from last week, cause you didn't bring yours. I don't have it with me.
Wait, is that an obituary sheet?
Who needs one of those? You had one last week. You have it in your folder that you brought because you didn't do anything with it. That's all right. Okay. Today, she put it in your packet today. Look in your packet. Got it. All right, so you got a pencil, because there was a pencil in your packet today, right? Our pen. All right, so we're gonna fill it out. Those that didn't bring, fill it out. We're gonna make this a working meeting. You can get started today. Now, those of you like Sister Katie that have done her homework, she's one of those students that, people remind you in class, always does her homework, always does everything right. Yeah, those people. Sister Katie, did you bring your the spiral binder? Okay, so I want you to turn to a blank page because you're gonna go ahead and get ahead of the class. Ben, why are you looking at me funny? You got your sheet? Well, did you raise your hand so they could give you a sheet? You have one? You have your packet? You got your pen? Okay, well, start filling it out. Cause you said what? I didn't hear you, but if you have that, and you have it, start filling it out. Today, because you're supposed to do it last week, but you weren't here, so you're gonna do it right now. Fill it out, start filling it out. Okay, you look confused. I'm gonna come over here and help you out. Let's talk about that right now. This is you, they have the obituary, and they have all that information. We want you to fill this out, so we can start writing you off. But you don't have to think about your date of birth. Yes, right, fill it out. You got it? Right, just, okay, just don't do it. Just sit. All right. Anybody else confused? Anybody need some more instruction? Okay, Sister Kay. You know, I'll find out. Jermaine, you got extras? And T-Dub needs another one. Elder Teacher needs another one. Y'all can have plenty. What, Pastor Pat? You looking at me, what? Oh, okay. All right, so start filling, and the stuff you're filling in now is really stuff you already know. It's stuff you already know. You know your name, you know your date of birth, you know your maiden name, you know your mother's name. Some of the stuff you may not know. That means you need to look it up if that's what you want in your obituary. Because in my family, I can only go back to my grandmother. Some of you may want to put your photo in Girl Trek. You talk about, I'm the daughter of, and you go, I'm the daughter of Mary and Stewart, who's the daughter of, and Mary Young, who's the daughter of. And some of you can go, some of the ladies can go like way back. I don't go back to my mama's mom. You know, so. Are you from Morton, Arkansas? That's where my family is from. Huh? Jay, can I have another one of those sheets, please? Yes, ma'am. You put what you want. Because my mama, on mine, I didn't put her maiden name, I just put Mary and Virginia Stewart. Oh, well then put the maiden name, I don't know. Sister Thomas, speak louder. Here.
What I'm saying is, if it's your mother, Mary, use Mary, and never use anything.
Some people, when you said that, when you give your password, your stuff, and they say, what's your mother's maiden name? And then security, that's it. So, but for this, you can use. Everybody? We're live online. What if your brother's what? What do you mean? Oh, brothers and sisters, you know, in parentheses, they'll put, like my brother, his is Victor Stewart, and then parentheses, they have his wife's name, Ursula. So you can do that. All right, so Katie, I'm back to you because you did your homework. There's no need for you to be waiting on folks that did not do their homework. So what I want you to do, Katie, is start writing. All right, so in school, we used to do like story starters. When the kids would come in to take up time, and I put the prompt on the wall, on the board, to start the story. So you want to start your obituary. Now before we even go to the obituary, you don't have to have an obituary. You don't have to have that paragraph or 2 or 3 that talks about who you are and where you're from. You don't have to do that. You could just have your cover sheet with your name, your date of birth, the dash, and your last name, a picture of you on the front, and then that inside can just be pictures. You don't even know if you've seen these obituaries, and they're like 3 and 4 pages, 8.5 by 11, like really books. You don't
Get
have
your
to
house
do
in
that.
order.
It's what
Living
you
trust
want.
will
You can
find
do,
expensive.
and I've seen these too.
I'll call
You
you
can
over
take an 8.5 by 11, have it folded in half, and that's your obituary. Front is the picture, or not. Inside can be whatever order of service, if you have it in service. Over here can be some pictures you want to have dropped in there. The back can be thank you for coming. A poem that you can pull out, and that's the other thing we can do. On the back, can be a poem or something, thank you. If you're having the mortuaries handling your business, now your name is stuff like that. You don't have to have an obituary. Okay? But traditionally, in the Baptist church, we have obituaries. So, that's why we're doing this, because sometimes, and I'm guilty of it, I've written mine, but I haven't touched it in a couple of years. More like I looked it up last week. 2017 was the last time I updated. And since then, stuff has happened. Since then, I changed my mind about what I want to say. And I was telling you last week that I found out, I went to a service and I didn't know that you could pick your own, you could pick your own scriptures for your thing. I know you can pick your songs, but you can pick your scriptures. I thought the preachers picked the scriptures, but you can pick your own scriptures, you can pick your own songs. I had decided that I was in this phase at my service, we just don't have all women preachers don't do a women's service. Women don't officiate, we just don't, it's gonna be the day of the woman. And I had, then I was like, who am I gonna have to? Who am I gonna have to? Then you start, it's hard. Because so-and-so does this, and I want so-and-so to do this, and I want so, and then it's like, but I got more people, and then I got room on the program for them. Who gonna get left out? So then I said, so I involved, I don't know if I'm doing that or not. I also said I was gonna have Pastor Jackson do my service, preach my eulogy. But I changed my mind since then too. So this is a living document. You don't have to be stuck on what you write. Some of the information, if you choose to do our standard obituary, your date of birth, your mom and your daddy, your brothers and your sisters, that will stay the same. But this can be anything you want it to be. And like I told you before, those of you that weren't here, this is the first time I went to a service, our pediatrician died. And I went to her service, and it was beautiful. I'd never seen a service like that before. There was no obituary. There was no traditional like we do traditional. She had a woman up there that just kind of talked through her life, talked through, and they did have a video. But it was beautiful. It was like, ooh, I would love that, but now I have nothing to bring back with me to kind of copy it, right? So, but I guess what I'm trying to say, this can be whatever you want it to be. You don't have to follow the traditional thing. Those of you that just walked in, if you didn't do your homework last week, we're asking you to fill it out. If you did do your homework last week, we'll get to that part in a minute. I wanted to mention also, if you go online and Google obituaries, there's a wealth of information. There's a wealth of just samples. There's just, and you can do poems, like, you know, usually they have these, you know, God came to the garden and picked the flower and picked my mom and she's now in this, you know, you've seen happening. They have all kinds of stuff online. So I would suggest, because, you know, nobody likes to talk about and think about their home goal. Nobody likes to talk and think about not being here. But I would suggest that you start thinking about it. And not for you, for the folks that you're gonna leave behind that have to do the work. That have to put together the obituary, the order of service, have to go dig for your stuff and find out where your bank accounts are, and all of that stuff. Who you, life insurance policy. And also, make sure if you, say for example, I'm gonna use Ian. He's my friend, you don't want to use, let's build it on Deacon is on. So, BM, he got a bank account when he died. And he put his mother as the beneficiary. And he never changed it. Now he's married to the beautiful, wonderful woman, right? But he never transferred over to the beneficiary. So if you got checking accounts that have beneficiaries that you put on there at an early part of your life, or maybe you married and you ain't with that person no more, and they still on your checking account, you want to go to the bank, your credit union, your insurance things, wherever you have old beneficiaries, and change it. Because when you leave here, and you got $100,000 in this account, and that person that you could not stand, that's why you left them, but you can change them on your beneficiary, they don't get all that money if they still here, right? So it's something we tend to forget. So please make sure you check your checking accounts, your savings accounts, your life insurance policies, who the current beneficiary is that you want. Okay, so you guys have, I'm sure you filled in the basic stuff on here. And again, Anna was asking, suppose you have brothers and sisters that are married, you put the brother or sister's name, and then in parentheses, you put the spouse's name. Now, everybody got a notebook? Yeah, everybody got a notebook? Take your notebook out. Keep your worksheet handy. Because now we're gonna do some writing. And I know Ian says I like to think about my stuff. You still think about it, but at least get this part filled out. This one doesn't require any thought. Okay, so one prompt is, you can write it in the first person, or you can write it in the third person. I think I wrote mine in the first person. Oh, because I wanted to share, I shared last week. The reason I got into doing this thing is because you're going to be going to these funerals, and you have these obituaries, especially if you know the person, like, you read it, it's like, so, what you want, or you know that that's, so what I decided was, I'm gonna write my own obituary, because I want what I want, and how I want it said about me. So, many of you may not care, or not have that little sarcastic kind of cynicism, attitude or whatever. So, you know, you may not, doesn't matter, but it mattered to me, I wanted to write my own. So, I wrote it in the first person, and you can write yours first or third, like past tense. So you can start with, if you are reading this, that means I am not here. I left this earth on such and such, such and such. I left behind, you know, I'm the daughter of the son of, Joe Blow and Sister Blow. And so that's one story starter, because now we're writing. This is just to get your brain. You're not gonna finish it today. It's like Leon said, he needs to think about this. I had to think about mine too. Okay? Another story starter, writing in the third person. Linda Ursery-Fleming was born on November 3rd, 1953, in the city of Los Angeles, California, the General Hospital. She married such and such, so and so. I should say his name. She married Lemuel Anthony Fleming, and from that union they were two lovely daughters, Leah and Lauren. So you can start it that way. You can start yours. What was it, Panay? You told me you guys didn't call it obituary, you called it a bio history, bibliography, or some word you don't remember. Some word she used last week. Do you remember, Cheryl? What do you call it, Cheryl? A biography?
Uh-oh, sure. That happens.
So that's how mine is going to be written for what?
Come over here. Work this portion and her camera's off.
He's never realized that that person knows it's me. And then just go on and put the date and actually get that. And just generally not total information about my life, but just things on the way what I want them to know. Oh, I paid her $2 so I can add.
All right, I think that's a wonderful story starter. Anybody else have some wonderful story starters? Because this is a story. This is a story of your life.
I just thought it was fun. I said, yes, I am in the presence of the Lord. I'm so thankful that God gave me the gift of life. And then I'm going to go and talk about my children, and that I want to see them with the Lord, not in church. I want them to get in church. And I'm going to be saying, I want to voice to my folks.
Okay, so another way to start, and in my obituary, I do have a little, what they call it, proselytizing, whatever that word is, encouraging people to, they need to find the Lord, they need to know the Lord, because, that's the whole point of us being here. Live this life so that we can be with the Lord. So again, this can be whatever you want it to be. Any other story starters? So far, has this been helpful? Okay. Because my time is almost up. Anybody want to share the beginnings of their story? No, it's yours.
It says, if you're reading this, I'm dead. And I'm and I'm no longer here with you, but I'm with my Heavenly Father. I want to tell, I love you all, but we're not having no mess. We'll have the reading of the will and trust after my services. When I get up and start talking, I don't want a long service. And I want us to be outside and not put me indoors.
this is yours. It can be what you want.
Well, I like things to be funny, and I already told my nephews if I'm laying on the bed, I'm going to be there telling me some of those Bonner jokes. And so I would like to say, if you are here, I am not. And then just go into some funny stuff. And, I just like to laugh.
I would like somebody sent a text from my phone, Jalen, and thank you.
I would want mine to be very simple. I just put, Dolores lived a great life. What are your thoughts? And then we pass the mic.
With your family, we over here,
Whatever you guys do not put me in the ground. I do not want any worms crawling on me. I want to be above. Cremate me.
and some of these things that you're saying, those are instructions, directions, that you need to leave in writing. You don't have to be part of your obituary. Like I already told my family, well, I already bought my cremation package, Smart Cremation. And because my mom said, my mom died, before she died, said, Mom, when you die, we gonna cremate you. My mama could cuss. So of course she started cussing. And then I said, well, Mom, you're not gonna know, you're not gonna be here. We can do whatever we want. Then she started cussing. So we did honor her wishes. We didn't cremate. We didn't cremate. But those are the kind of things you want to put in writing somewhere. Like I already told Drew, he said if he's here, he'll make sure it happens. And I told my family that my procession, I want my song. And my song is it's something for Jamaica. That's my procession. That's my procession. That's my song. You know, so those are the kind of things you want to leave with your family so that they can, you know, they may or may not honor your wishes, but at least you've left them, right? They don't have to wonder. Rhonda?
All of the important information needs to go in writing into your trust. Because otherwise the family is going to be bickering and it's going to start a whole lot of mess. It happens all the time.
All right, so that brings up something that we haven't talked about, but the trust. Your trust, your will, living trust. And you can Google online, LegalZoom. There's all kinds of ways, but like I said, we don't like to talk about death. We definitely don't want to talk about last will and testament. So there's a lot. So this is just a starter to get you to thinking. If you, how many of you have a will or trust already, a living trust? Okay. If you don't, you need to. You can do them simple, or you can get a lawyer and have it done. But you need to have it done. Not saying that even if you do it, there's still not going to be mess, because you know people are messy when there's money involved or assets involved. But at least put it in writing so that folks that you want to get what you got, they can get it. And if, I already know my daughter's told me, Mom, you need to tell us what's valuable because we throwing everything in this house away. It's like, okay, and so I did, and there's still no guarantee, but she already told me, when you leave your mom, we're gonna take that garden that you got out there, that desert, we put a shed, we're gonna turn that little room into a IMP, APD, whatever. AUD, ADU. And we will turn your office back into a bedroom, so it's a 3-bedroom house, and we can rent it out. You know, I'm like, okay, can you kind of wait till I leave before you? So our kids are gonna do what they gonna do, whether it's trashing it, but at least leave them some type of guidance when you do leave. All right, any other, yes, okay, I was sitting there ready to ask some final remarks or questions, because I'm about done.
Have a living trust, that's the purpose of having a living trust, because you have someone, your executor, that's in charge of it, that's gonna see that your wishes are taken care of, period. There won't be any fussing and fighting, because you got somebody who you know can handle the business and with the family.
I don't care who you have, it's still what it is.
But it'll be less because I have a clause in mind. Anybody protesting what I want, take their portion and divide it to the rest of it.
I just want to be clear on the living trust, because I only have one child, and I was told that you have to have, even though if you don't have no will or no living trust, that it will go to the state, and the state make the decision. And I have to have something in place that which I know everything I have, you know, with pursue the beneficiary, but I was told that that's why I came here today to see, am I to make sure that I have a living trust or some kind of will in place with her, you know, her name and information.
We actually have a person who can answer that question for you. So this is gonna be our next speaker. I'm gonna have Kamala. Yes. Yeah, I wanna close you out, but I just don't want people to start asking questions on that subject.
That was a good question. That's a good segue question. Before I sit down and start learning, any other stuff? I'm not the one to ask. I already paid for my cremation. Oh,
I'd like to share a personal experience.
With the camera
I have a nephew that died in Virginia. His son had already passed. His wife had passed. He never updated. So when it came time to distribute his last wills, his property, the state got involved, and 80% of his assets got eaten up in fees and penalties. So to answer the question, that yes.
all right. I want to thank you all for coming back, those of you for the second day, and those of you for the first day. Hopefully, what you've heard over the last 2 days has been beneficial. We have a gift for you. So I will pass them out as we transition to our next segment of the morning.
Okay, I was trying to close it out. I want to apologize for that, but I just want you guys to ask me questions. We have an expert that actually answer those questions for you. So I'm going to have Sister Elder Kimberly introduce her as the speaker.
Well, good morning, everyone. I love that. All right, I am here to introduce my friend. I'm gonna read her bio, but I'm gonna tell you what I love about her the most at the end. Kizuwanda Walton is a highly respected estate planning attorney with a deep commitment to assisting individuals and families in securing their legacies. A native of Southern California,
born in Los Angeles and raised in the Inland Empire. I call her Wanda. Wanda brings a unique understanding of the local community to her practice. She earned her undergraduate degree from UCLA and went on to graduate with honors from the University of Miami School of Law, obtaining her Juris Doctorate. During her 17 years, just don't let the baby face fool you. During her 17 years as a practicing attorney, Wanda has demonstrated a strong commitment to public service. She has been appointed by the court to represent indigent individuals and has provided pro bono services and legal resources to various community-based organizations. Presently, as the owner and manager of Walton firm and estate planning and trust administration law practice, Wanda continues her dedication to serving her community. She is recognized as a California Bar Certified Legal Specialist in her practice area, showcasing her expertise and commitment to excellence. And in case you don't know, when somebody is a certified legal specialist, that means that not only did they pass the bar exam, they went and took extra classes and passed another exam, meaning she's the cream of the crop. Right? So beyond her legal practice, Wanda is deeply involved in community outreach efforts, volunteering her time and expertise to educate individuals and families on the importance of estate planning. She's an absolute wonderful mother. She is a member of Jacksonville. And I'm proud to say she's going to be the next president very, very soon of the Ursery-Fleming Bar Association. And so without further ado, I'd like to welcome my friend. She's not only a lawyer, she's a Christian first. That was the first thing I loved about her, was her demeanor, her attitude. You guys are gonna love her. Ask her all the good questions, because she's the best.
Hello, everyone. I'm so grateful to be here with you guys today to share. Hopefully, you will learn something about estate planning and moving in the best way. You can do that with your family. Is it ready? Oh, it's not. Can you guys all hear me? Yeah. There you go. Thank you. And our first speaker has some great information that will be guys well. Is what we're going to talk about. Let's come back to that. Okay, so my presentation is what happens when you die. And there's a few things that we're going to go over. Hopefully that in this presentation you know, particularly what happens during probate and what exactly is probate. How wills are different from the trust, how to save money to provide for your loved ones, and then how an estate plan can be helpful for you and your family. We can go to the next slide. Next slide. So does anyone have experience with the probate process? Has anyone ever gone through probate? Good. Everyone. It's normally not a pleasant thing. So I asked them what they were doing. Asked them through that process. It was a nightmare. It was horrible. It took forever. It cost a lot of money. So we're going to go down two paths today. The first one, we're going to go down the path. What happens when you die and you have to go through probate? So we can go to the next slide. So what is probate? And you can go to the next slide. All right, so probate is a legal process. When someone passes away, the court uses this process to distribute that person's assets. It's used to transfer money, other assets, real property, pay creditors, and it is different in each state. So we are going to specifically be talking about California probate. What happens if you pass away in the state? Next slide. So when is probate required? There's a few elements to this. If you're a resident of California, you own property here in California, and if your assets are over $184,500, and that number does change every year. So that's not a fixed number, but that's the number currently. And if you do not have your assets in a trust. So there are some smaller states, let's say you own less than $184,500, you will not have to go through this process. If you pass away and you have a spouse, there's also a process where you can just transfer assets to your surviving spouse. There's a couple of ways that you can avoid probate without a trust. but for the most part, if you're a resident of California, you own real property or assets over 184,500, and you don't have a trust, you're going to have to go through this process. You have a question?
No, ma'am. One moment, please. One moment, please.
Oh, sorry. Thank you.
That's there. Okay, so California, we know that like real property is not even there.
It's really high.
So if you own, say you just own a house and there's still a mortgage on it, is that number about the mortgage where you own your house outright? And then they're saying this is what we estimate the value of the house.
So there's actually going to be a slide on that a little bit later, but it is the value of the home without counting for the mortgage. So whether you have a house that's worth $500,000 and you have a $400,000 mortgage, the court will look at that as if you have a $500,000 asset, even though you really only have $100,000 in it. We can go to the next slide.
Did it go?
So
Oh, wait, it's not going.
this one did it, but that's okay.
Okay, it's not going. Go.
All right, so these are some common probate terms you might have heard them before. Person who handles your probate is called your executor or your administrator. Person who are receiving your assets are your beneficiaries, are also called your heirs. Person who passed away is the decedent, and the way you start a probate process is with a petition. It's like a formal document that gets filed with the court. The last one is letters of administration, and that's basically like a court order that says the executor or administrator has authority to act on behalf of the person who dies. Next slide. So this is kind of a timeline of the probate process. Probate in California requires a minimum of like 6 to 8 months because there's notice that has to be given. So there's just some minimum requirements. But most probates last much longer than that. At least about a year, but typically longer. So it starts with filing a petition. If you have a will, that gets filed as well. Your administrator or executor gets the permission or authority to act on your behalf, which is the letters, and then they go through and prepare an inventory and appraisal. They gather all your assets. They have your home appraised to find out the value of your estate. They have to give notice to creditors because creditors have to be paid as well through this process. They manage all the assets, prepare accounts, pay everyone, distribute assets, and ultimately the probate process is closed. Next slide. One of the biggest, most important things that I can help our community understand is that if you receive Medi-Cal benefits, the state of California is a creditor. If you die and you have assets that are not in a trust, the state of California gets kind of first dibs on those assets, and they will come file a claim to recover from your estate. So I've seen probates where a family has just one house, and basically when they pass away, Medi-Cal is notified, they file their claim, which is $300,000, $400,000 for all of the payments of it, or all of the medical treatment that you've received over the course of your time receiving Medi-Cal, and that entire estate goes to the Medi-Cal outstanding balance. So we can go to the next slide. So in calculating probate fees, right, you have filing fees just to start a probate. On top of that, there are statutory fees. So if you have an attorney working with you, they're entitled to statutory fees. The executor is entitled to the statutory fees as well. Once again, if you have a person who had one home, about $500,000, $200,000 mortgage, and someone already asked this question, what is the estate? Is it $500,000 or is it $3? And the court would say it's a $500,000 estate. It does not account for the mortgage. So your fees would be based on that $500,000 amount. And it's statutory, so it's a percentage. So the first 100,000%, I'm sorry, yeah, the first $100,000, 4% of that, and it moves up so on and so forth, as you guys can see on the screen. In light of that, this $500,000 estate has attorney and executor fees of $26,000. That's not including the court filing fees, publication fees, and bond fees that the court requires. What happens is, if the family doesn't have the $26,000 to pay these fees, what do you guys think happens? They sell the home. home has to be sold to pay for these fees. So it's really, really important to understand this because a lot of people want to keep that home in the family. There might be other family members still living in that home. So you want to find a way to protect the house and not have to pay all of these probate fees if you can. We can go to the next slide. Sure.
Go back to this one.
Yes.
Now, we pay. Now, is that in your house in the balance that's over that account? Or is that the money that the account uses to service you?
It's the money that is paid for any services you receive while you are a recipient of that account. So I don't know that there's any deduction for anything that anyone has paid in because it's a state-sponsored program.
You have Medi-Cal. You got, you have to pay Medi-Cal back.
That's right.
And any services that you had prior to you got.
That's right. Yeah.
Is that only through probate?
So that's only if your assets go through probate. In a sense, because there's a current law that just went into effect maybe in the last 5 years or so, maybe 2020, that said net house can only recover from the probate estate. So any assets that go through probate. So this next section, we're going to talk about how to regulate probate.
I have one more question. So if probate only happens when people can't get along, fight on stuff, or there's no trust.
Right, probate happens, basically, the default. Everyone's going through probate unless you do something different, unless you set up an estate plan, unless you name beneficiaries on all of your accounts. Otherwise, everyone's going to go through probate. Yes.
Okay,
you have another
and I
question?
think that was similar to what you just said, may touch on my question. So let's say I have a life insurance policy in place and I name my spouse, and I don't have an estate plan, would I still have to go through probate?
So there are different kinds of assets. Real property is going to be very specific. You're going to want to make sure that's in a trust because there's no way to kind of avoid. There's maybe one way. With life insurance, that's what we call a pay on death account. Bank accounts can be pay on death or transfer on death accounts. Sometimes even retirement, where you can name beneficiaries directly. Those assets are not going to be prorated if they have a beneficiary directly listed. And then we have one more question. We're going to pass to the mic.
If you have a family that has 6 or 7 family members and they're fighting and if you have a will and everything, is that another way that they do probate?
So if you just have a will, you're going to go through probate if your estate is over and yes, your family can get out in probate. The will does provide instructions, but a will has to go through probate. And we're going to get to that point in this slide as well. Now, even if you have a trust, our last speaker did mention, if you have a will and a trust, things can still get complicated, things can still get messy. But at least you have something in writing, you have instructions, and you have documents the court will uphold and follow. So even if your family is driven, you have something in place to protect your estate. Okay? All right, we're going to talk about now what happens when you do some estate planning before you got it. Next slide. So when I talk about estate planning, estate plans can be a variety of different things, but this is a typical estate plan. We're talking about a living trust, a pour-over will, a power of attorney, an advance directive, a HIPAA waiver, and then any life insurance, transfer documents, and there's one more at the bottom that we can see. It says life insurance and disability insurance as well. I like to include those because it can be a really important part of a comprehensive estate plan. We can go to the next slide. So this is my biggest question I get, and I think we might have skipped one, but the biggest question I get that most commonly asked is, what's the difference between a will and a trust? So we're going to kind of break that down right now. We'll go to the next slide. And a will is a document that is effective. You write it during your lifetime, and it's effective when you pass away. During your life, you can always update it, change it. When you pass, that's when it becomes effective. And it typically distributes your assets. It says, I want my house to go to my son. I want my car to go to my daughter. It has a list of those things. A will requires probate. people say, I have a will, I'm good, right? I don't have to go to probate if I have a will. No, if you just have a will, you have to go through probate. So we talked about this person who handles your affairs under a will as your executor or your administrator. A will can also be a place where you name guardians for any minor children. So if you're a parent with young children, this is where you would say who you would want to take care of your kids. A will is also public record because if something happens to you, it has to be filed with the court. You know, people have access to those court records. Next slide. We're going to emphasize this. Wills require probate. If you just have a will and your estate is large enough, you will have to go through the probate process. You're not going to avoid Medi-Cal. You're going to have to take this time, pay the probate fees to approve if you just have a will. Next slide. So a living trust is much different. It's much more comprehensive than just a will. It is effective immediately when you sign it. So you're going to create this document during your lifetime, and it's going to take effect immediately. You can update a revocable living trust. You can make changes, but it is protective during your lifetime and after you pass away. A living trust does not require probate. The person who manages your trust is a trustee or successor trustee. In California, this is a private document, so no one has access to this except for the people you give authority to. I'd like to explain that a living trust is similar to a business entity because it can hold assets. You can title your home in the name of your trust. You cannot do that with a will. And like I mentioned, a trust can be revocable or irrevocable. Revocable means you can make changes to it, you can update it. Irrevocable means once you create it and you put assets into it, you can no longer make changes. And there are some reasons why people do that. Sometimes those are tax reasons. Sometimes they are, they have a person might have liability to creditors and they want to protect the assets, so they'll put it in a irrevocable trust. But you have to understand when you do that, the reason why your creditors can't get to it is because you no longer own it. It is not yours anymore because you can't make changes. We have a couple questions. Who has a mic? So the question is, if you name a trustee and they pass away before you, do you need to update your documents? So yes, you will always want to keep your trust updated. When I do estate plans for people, I typically ask them for at least 2 successor trustees. So while you're living, you are your own trustee. If something happens to you, you should have at least 2 backups. But if something happens during your lifetime where you know your trustees you've named overpass, become ill, are not going to be able to do the job, you want to update your documents. You want to amend them so that you can put someone appropriate in place to manage your affairs. I'm not quite understanding the question. You're saying you have an executor, which is the person under your will. If that person passes away, yes, and you want to update your will to make sure that you have someone who can act in that capacity. Now, you're probably the executor. My brother passed. Yes, so you're the executor. Who is she? Who's will? Okay, your mother's will has you as your brother as the executor, but your brother has passed. Your mom should update it so that there is someone living who can manage her. You're with him. Okay, so then she doesn't have to do anything because you're already next in line. All right, so we can, oh, we have another question?
Can you explain the revocable and irrevocable?
Yeah, absolutely. Absolutely. So traditional trust for estate planning is going to be a revocable living trust. This is like a living, breathing document. You will update it during your lifetime. as your life calls for it. Because when you are younger, let's say you do have young kids, your life might look a little bit different than when you are older and you have adult children who take care of themselves. So that revocable really means you can make adjustments, amendments, modify during your lifetime as your life needs. Irrevocable means you cannot make changes. So once you create the trust, you move assets into that trust. You cannot take them out. Those assets now belong to the trust. When you set up an irrevocable trust, you might be able to benefit from those assets during your lifetime, but you have named beneficiaries who are now the ultimate beneficiaries of those assets. For instance, sometimes people will move their home into an irrevocable trust and continue to live in that home. But if they got sued by their credit, they had some outstanding lawsuit, they lost and had a big judgment, their creditors can't get that house because it does not belong to them. It belongs to the beneficiaries of the irrevocable trust.
Okay, so, I have a trust.
Yes. It's probably revocable. That's pretty standard. You would probably know if you have irrevocable trust. Most people don't use it under them. Like I said, they're very limited circumstances. Asset protection, reduce taxes, avoid creditors. Those are the typical reasons people will set up an irrevocable trust.
And once you put your home in an irrevocable, you not change.
That's right.
That's where your life.
Mhm.
There, right on.
Yep.
Can you have both? Like, can you have this stuff is in the revocable one, and this stuff is in the irrevocable one, all under one umbrella, or you have to have two separate?
You can have as many trusts as you need. And so when we look at larger estates, many people will have 10 trusts, just depending on what assets they want to go where and what they're trying to accomplish with some of those assets. So I have some clients who have very large estates. They will gift their spouse $10 million, for instance, and put it in this irrevocable trust for the benefit of their spouse. They want their spouse to be able to use that money, but they really don't want that spouse, if they got remarried, to give that money to a new spouse. They want that money to go to their kids or grandkids. So they would put it in an irrevocable trust for the benefit of their spouse or their spouse's lifetime. And after their spouse passes, that money is going somewhere that they want it to go to, not where the spouse wants it to go.
Okay, and then, so you answered one part of that, team trust. At what point would you say to the client, recommend, hey, this might be the goal to?
So typically, my clients are looking for some sort of asset protection or some tax planning is when I would recommend an irrevocable trust, but not for most estates. Most estates, people are really just trying to protect their assets from going through the probate process, losing assets to Medi-Cal, and they really want to have the flexibility to use their assets the way they want to. They might want to sell their house, they might want to upsize or downsize or leave the state, and they want to have that ability. With the revocable trust, you have the most flexibility to do that. I'm going to add one more thing. Even with your revocable living trust, when you pass away, if you're a married couple, typically when the second spouse passes, the trust becomes irrevocable, meaning no one can make changes once you're gone. Sure. So with your revocable trust during your lifetime, you can make changes. But once you pass away, your trust becomes irrevocable, meaning nobody can make changes because the only person who had authority to do that was the person who has passed. We have a question back there. Right, so the question is that just when both spouses pass? It does depend on the type of trust you have, but if you have a traditional revocable living trust, or both spouses have authority to revoke them in, yes, it's typically when the second spouse has passed that the trust becomes irrevocable. Sometimes we set up marital trust that when the first spouse passes, half of the trust becomes irrevocable, and the surviving spouse still has control over their half and can make changes, but the spouse that has passed make sure that at least half of the estate goes where that spouse wants it to go. We have another question way in the back. So the question is, where is the best place to hold a nonprofit if you're doing your estate planning? Is that right? Nonprofits are actually kind of unique. I don't know if we can even call them assets, because nonprofits have legal requirements that if the nonprofit, that the owner or the person who creates the nonprofit is not an owner, right? Those assets do not belong to the individual, they belong to the nonprofit. And even if that nonprofit were to dissolve, it would have to distribute its assets to a similar nonprofit. They can't just disperse those assets to your beneficiaries. So you want to make sure that with the nonprofit, you have good governing articles that dictate what happens if the nonprofit were to dissolve, or if the, I'm trying to remember the term, the directors of the nonprofit are not able to manage it any longer. Yes.
What situations for taxes? How would you use a revocable, the irrevocable trust for tax purposes?
So we're gonna get there, and it's gonna be brief, but we'll get there at the end, because there's a really, you have to have a really large estate today in order for taxes to affect you. So we're gonna get to that number. We can go to the next slide, and we'll get to the questions now. Go ahead.
I would like to stop the questions for a few minutes so she can finish her presentation, then just write your questions down, and then she can answer afterwards.
And I'll try to answer all the questions that I can. And we might get to some of them as we go through the rest of the slides. So, why do you need an estate plan? We've already gone over a couple of reasons as we've discussed, why you might not, want to spend all the money, and why you might want to avoid creditors. So we can go to the next slide. So the first reason is to provide for loved ones. This is the reason that most people think of when you think of any movie, and I think someone mentioned it earlier. You think about family coming together and the reading of the will to see who's going to get what. And yes, this is an important part of estate planning, but this is not the only main reason, and it's not even necessarily the most important reason why we should do estate planning. When we're providing for loved ones, you want to think about what your family's needs are today. Are you the primary breadwinner in your family? If you were to pass, could your family continue to live the life that they're living without your income? Do you have enough life insurance to cover your expenses? And that number is going to change depending on what stage of life you're in. If you have younger kids, you're going to want to make sure you have enough assets to get those kids to adulthood. If you don't have young children, or if you have adult children, you may not need as much because your expenses might be a lot less, and there are less people relying on your income to survive. Another reason is, for instance, if you do have minor kids, if something happens to you and you have a 12-year-old, you may not want that 12-year-old to, and legally they can't receive the assets, or even if you have, let's say, an 18-year-old and you have an $800,000 estate, you may not want that 18-year-old to have that money in their hands. You might want them to be a little bit older, a little bit more mature, so you can set up a trust for the benefit to help with their education, their medical expenses, any of their support needs, but you might say, I want to distribute this maybe 25% at age 25, 50% at age 30. Whatever you want, you can set that up in your estate plan. Some people also have special needs beneficiaries where if you leave a person who's receiving like Social Security disability, if you leave them assets, it won't interfere with their ability to receive those government benefits. So what people do is they will leave those assets in a special needs trust. So your loved one can continue to receive their government benefits, and they have a supplemental trust to help pay for any other needs that they might have. So when we're thinking about providing for loved ones, we want to think about all of those things, not just giving them assets, but making sure that we're also protecting them. One more category is sometimes we're caring for an older family member, whether that be a parent, a grandparent, an aunt or someone. And if something happens to you, you may be able to survive. We want to make sure to take care of the estate as well. We can go to the next slide. protecting yourself. When we do an estate plan, we're not just thinking about everyone else, who we're gonna give stuff to, we're thinking about ourselves as well. All of your assets in your estate should be used to take care of yourself first. So with your trust, as I mentioned, that document is immediately effective. It will, and it should say, any of my assets should be used to take care of me. I become injured, unable to manage my affairs, have an accident, dementia, I can't manage my things myself. We have a power of attorney in place, which will name someone to manage your financial affairs. We have an advanced directive, which is kind of like a medical power of attorney, so that you are naming someone to make medical decisions for you if you cannot make them yourself. So you want to also protect yourself. We can go to the next slide. You want to plan for your assets. When someone asks about a nonprofit, right? You might have other business entities. You want to make sure that your governing business documents have the appropriate outline of what should happen if anything happens to one of the owners, of where assets should go. And then you also, if you do own businesses, you also want to incorporate them into your trust. We can go to the next slide, which is going to be about digital assets. This is a relatively newer area, but it's often overlooked because these are not traditional accounts that people do have. Robinhood, Facebook, cryptocurrency, Bitcoin. You want to make sure that you plan appropriately to get those things into your estate plan and typically to your trust. Next slide. So the trust, some people describe it as a backpack, and then picture, you have it there. It is holding all of your assets. So whether that's your home, you're titling it, it can hold vehicles. You can name your trust as a beneficiary on any brokerage accounts like mutual funds, retirement accounts, life insurance. So that if something happens to you, any funds funnel into your trust, and then your trust will say how those assets should be distributed. You can go to the next slide. So, biggest reason for most people is to avoid probate, and you guys know why. We talked about probate, we talked about how much it costs. So you can go to the next slide. If you have your assets in a trust, once again, you are avoiding probate. If something happens to you, your trustee can immediately take over and manage your assets and distribute them, which means we are avoiding all of these high probate fees. You will not have to pay any of those fees if something happens to you and you have a trust and appropriate beneficiaries on all of your accounts. We can go to the next slide. And most importantly, Medicom cannot recover from assets that are in a trust. Now, someone asked a specific question about your home. There are instances where there's something called a transfer on death deed. And sometimes I hear people that someone's asking a question, I just have one child, what do I do with my house? And they'll ask me, should I just put my child as the beneficiary on a transfer on death deed? And what a transfer on death deed does, it says, I own my house, if I die, my property goes to my son. That gets out with the county recorder. When the parent dies, all the son has to do is file a death certificate, and that house transfers to the son. But California has a law that says if you have that kind of deed, the son has to notify the child. So Medi-Cal can come and make their share. The only way to truly avoid that is if you have your property in a trust. And I will say this, that's the state of the law today, and the law is always moving and changing, but this is a huge one because I see a lot of the states that get lost to Medi-Cal. We can go to the next slide. And then reason number 5 is to reduce taxes. So, right now, currently, presently, 2024, if your estate is under $13.61 million, there are no federal state taxes. If you are married, you get to double that number. So about $27 million in estate can be passed to your beneficiaries tax-free. So it's a pretty big number. So most people fall outside of the realm of tax planning. In the state of California, there are no inheritance taxes, and there's also no state estate taxes. So if your estate is under $13.61 million, you will not be doing any tax planning typically. If you're getting close to that number, you might want to consider it, because that number is actually scheduled to drop to somewhere around like 6 or 7 million next year. The annual gift tax exemption is $18,000. So this is another way that really will try to offload some of their assets. You can give up to, in 2024, you can give up to $18,000 away without getting taxed, in a sense. So if you have 10 kids, you can give them all $18,000 every year without having any tax consequences on that amount. But the moment you give them $19,000, that $1,000 may have a tax consequence. So when we talk about irrevocable trust, a lot of people in this year are trying to offload $13.61 million, put it in irrevocable trust, make that gift, because they know that next year that amount might be lower and they might lose the ability to do that. I know. Okay, so we can go to the next slide. Oh, question. So the question is, when you give a gift, when you give it to the person who receives it, is the person who receives the gift the person who has to pay taxes? No, it is the person who gives the gift. Yes. Okay, so the question is, did California recently change a law affecting how parents pass their homes? And yes, that was Prop 19. Previously, if you owned homes in California and you passed away, you could pass all of the property you owned here to your children tax-free, and they could keep the same tax rates. So what changed is now it has to be only your primary home. So the state was trying to get rid of the people who had a vacation home here and multiple homes and were just passing wealth to their kids without paying them taxes, right? So now if it's your primary home and you're passing it to your child, and it will also be their primary home, and the home also has to be under $1 million, then your child can inherit that home without any additional property tax increase. You have a question?
I'm just holding questions. More questions, please. Write down.
Next slide. You have a question? Okay. All right, so we've reached the end. Here are the other frequently asked questions that I get. I'm not rich. Do I still need an estate plan? Everybody needs some level of estate planning. You may need to talk to a lawyer depending on what your estate looks like. And there are resources online. I don't necessarily encourage you to use those, but I would rather you have something in place than nothing. So if you need to go to legal Zoom or you need something, at least you have something in place. But at minimum, you're going to need an advance directive. You can often get those for free from your doctor, right? You want to know who's going to be making medical decisions for you, and you want to put your wishes down so that the person making those decisions knows what you want. Same with power of attorney. Those are very simple documents. You can definitely find those for very relatively cheap. How much does the trust cost? How can I find an estate planning attorney? There's a wide range, and it's going to depend on the needs of your family. So I would say, like, if you go online, you can probably find a trust for like $300. It's going to go into the tens of thousands. So it's a pretty wide range on what a trust will cost. Like I said, it also depends on what kind of trust you're setting up. So maybe if you're doing special needs trust or irrevocable trust, those are going to cost a lot more. But I would say like a good average standard amount is somewhere around, I would say under $5,000. And there are resources to find attorneys. There's the LA County, San Bernardino County, so we're kind of on the border here. We can contact the Bar Association. They have referrals for attorneys there. Of course, if you know someone who make a referral for you, I think that's always a good way to go. If you know someone who has to work. And then yes, you can use online resources to create your own estate plan. You can also handwrite your will in the state of California. Once again, I wanted to say I'm not necessarily endorsing these practices, but yes, you can do them. We talked about the difference between a revocable and irrevocable trust. We already handled that. And like I said, the number one question I have is, what's the difference between a will and a trust? We have covered that as well. So you can go to the next slide, which I think should have my contact information, And then if you guys have any more questions, I'm happy to answer. I also have a little flyer on me that as well, just some information on the estate planning. So that's a breakdown of what is estate planning, why you do it, and then what is trust administration. And we didn't really talk about trust administration today, but that is if you have a trust and you pass away, what your trustee is.
I have a question.
Yes.
I was gonna say if you have that saved.
So you do like Facebook and all that, how do you put that in your trust?
So let's talk about that, because I meant to talk about it when we were on that slide. You may not, so with Facebook, if you want someone to access your social media account, you have to designate that on your Facebook. You can list somebody you want to manage your account. I don't know if it's called like a legacy contact, but Allen has the same thing. Otherwise, they will lock everyone out. It may not matter so much with your Facebook account, but if you run a business or Etsy or Pinterest, you will want to make sure someone has access to those accounts to manage or wrap up any business affairs that you have.
All right, so I'm gonna pass mine.
When you talk about a trust administration, that's the, it's the administrator of the trust, right?
So trust administration is when someone passes away and the trustee has gathered all the assets, they have the trust document, they have their instructions, and now they're distributing. They're paying any outstanding bills, or finalizing any funeral expenses, they're managing the person's estate. It's very similar to what happens in the probate process, but it's outside.
Now, does that person get paid?
So typically a trust states whether a person gets paid or not. The trust may say yes, that person is entitled to fees, sometimes it may say no, it just depends.
And that can be whoever you appoint that person.
That's right.
Yes.
So typically there's a couple of different standards that are used. One is to give you a reasonable fee. One is based on what a professional charge to do the work that your trustee is doing. So you may want to put a number in there, but most people don't, because you don't know when you pass away what an appropriate amount would be.
I'm gonna put you on the spot. Okay. Are you accepting new clients, and what's like your basic rate? What's your basic rate?
Yes, I am accepting new clients. For a standard estate plan for an individual, it is $3,000, and for a married couple, it starts at $3,500. And once again, it depends on what your estate looks like. If you need any additional specialized trust created for your estate.
I'm with a company called World Financial Group, and we have had relationship with outside providers, and one of the cheaper routes would be net law. They do background check on this company, so it is a company that.
You said, what's the name of it?
Well, we're with World Financial Group, and they have a connection with net law.
Net law.
Okay. So net law, we with our company, they do have a bonus, a cheaper route, is like $600, that you don't have much that you need to do. Not a lot of money, but you do want to protect your home. This would be the cheaper route, but like you said, if you guys want something that you have a lot of property, a lot of assets that you want to protect, you want to probably pay a little bit more money for that services.
That's right, and there's some jobs out there who have legal insurance. I know of a couple from Auroch and MetLife where if you have that legal insurance, they will cover the cost of it.
Yes. So I'm assuming there are additional fees for like when you do updates, so what is that?
So for, it's, once again, it depends, so that would be an amendment to your trust, if you have a will that's called a codicil. And for me, I just charge an hourly rate, because it's going to depend on the number of changes you're making. Sometimes people are overhauling their whole trust, their whole life has changed, they're divorced, the trustees have passed away, or different, they've fallen out with family members, and want to remove beneficiaries, and want to just walk over. So that's going to be a lot different than, okay, I just want, my daughter's now 25, she was 10 when I made this, I want to add her as a trustee, so that would be a little bit more simple.
For properties outside the state of California, do you suggest putting them in I know it looks like I need to get a trust, but is it because I'm controlling a lot of it? and we want to make sure that my kids get to benefit from the property that we do own.
So there's some property at the state, you said that you don't control it. Are there other family members on this property with you?
Unfortunately, yes.
So I get this a lot of times. People here in California, they always have some property back east or in the south, and they got 7 people on that property, 3 of them have passed away, and it's a nightmare. So now that property has to go through like re-probate, and your part is in your trust, and you know, it's just kind of all over. So it can get really complicated with multiple people owning property, particularly when those properties are not trust, just in your own individual names. And even if you own a property outside of the state of California, you're going to want to make sure all your assets are properly transferred into your trust. Yes.
Okay, I have 2 questions. The first one is, do you do conservatorship?
I do not do conservatorship.
The second one is, I have 1 or 2.
Mhm.
And my oldest one, I'm probably talking about it. My oldest one, my youngest one, asked me to put the house in the trust. Now, I got 2 of them. If I put the house in the trust, would they be paying me and open that, and would they run up and go to the attorney, specify which you get along with it?
So when you set up your trust, so I'm not sure if the question was clear, but my understanding of the question is you have multiple children, you want to find out basically how assets will be distributed, if you have to go through an attorney to set it up to go to certain children, or to include all the children. And what I will say is your trust is your document. You get to set it up however you want to. Some people have 3 kids and they say, I haven't talked to one child in a very long time, or they have moved. Or they might say, my oldest child is very independent, does not want anything from my estate, and they will just leave assets to 2 of the children. Sometimes there's a big gap in their adult kids and a minor child, and the parent would say, if something happens to me today, I want things to just take care of this young one, the 2 adults are independent, it's fine. You can set up your trust to go to whomever you want. You don't even have to be your children. You can name a charity, you can name your church, for instance. You could name other family members or friends. You get to decide who you want to receive what. So when someone does their estate planning documents with an attorney, it's confidential. If your mother wants you present, I will always let my clients bring whoever they want into the discussions. And I do think it's helpful to make sure that, you know, their wishes are followed out, that someone knows what their wishes are. You do not have to be present with your mother, but if she wants you present, most attorneys will allow it. Mhm. If she's making changes to her own estate plan, you do not need to leave it. And I'm assuming mom has capacity, she's able to make her own decisions, she can do all of these things on her own. Yeah.
Before you started, I heard some people saying you should have a real land trust.
Yes, good question. So I brought that up. So I talked about having a trust as part of your estate plan and a pour-over will. So the pour-over will is a helpful document. Ideally, during your lifetime, you're going to move your house into your trust, you're going to move all of your assets, you're going to make the trust your beneficiary on any accounts, if that's what you want to do, right? But sometimes what happens is people create their trust, and then 5, 10 years later, they buy another house, and they don't move it into their trust. What happens to that house now? Probate. But we have this pour-over will that says it's sort of protected for your estate. And it tells the judge, hey, Your Honor, we meant to move all of our assets into this trust. We forgot to move this. Please move this home into my trust. After the person passes, it is helpful to get assets moved into the trust. We never want to use a will. We never hope to use that document, but we have it there just in case you did forget something. Yes, the pour-over will is a separate document from the trust.
I'm dead, my husband dead, My daughters are ones doing the thing. We forgot to put the rental in the trust. So the daughters can ask for a pour-over will?
No, so you've already created a pour-over will.
Oh,
Now
okay.
you have put your daughters in the position of they've gotta go to court to get that house moved into the trust.
So I create the pour-over before I die.
Yes, it's gonna be part of your estate plan.
If you get new property, does a pour-over will just kind of encompass the new?
Right, it encompasses any of your assets that are not in your trust. They're passing my stars.
Do you advise changing all your accounts, the name of it, to say the trust of blah, 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 like regular checking account? You would say the trust of.
So this, you can do it either way. You can name your bank account that you work out of every day, or be like the Kizuwanda Walton Living Trust account. Or you can name the trust, if you create one, as the beneficiary on the account, whichever is easier. Some banks don't allow you to name the trust as a beneficiary, which means you might have to change the name of the actual account to the trust. But either way is fine, and it might depend on your situation. For instance, I have clients who have blended families. On their bank account, they don't want the bank account in the name of the trust. Because if something happens to them, they want those assets to go to their children from their first marriage, not into the trust, which is going to name the beneficiaries of the current marriage. So it just depends on how you want to set up your estate, but both can work out just fine. Yes.
I got a question about
Yes.
the mortgage.
Yes.
Nobody talked about the mortgage.
Let's talk about the
Everybody
mortgage.
talk about paying for this house, like they paid off. They're not paying off.
It's not.
So how does it work with the mortgage company? If you finance up to the loan, all that.
So there are options. So let's say you pass away, you have 2 children, and the assets are supposed to be split between both parents, right? So you have one home, the kids have options, right? They could sell the home, if there's proceeds, when they sell the home, that mortgage will be paid off. But if the kids want to keep the home, the kids will either assume the loan, meaning they'll talk to the mortgage company and take over that home. They can qualify for their own loan on their own and kind of sort of pay out the old mortgage company. They can also just keep making payments in most cases. Most of the time, mortgages have a clause that says when you transfer title, we're going to accelerate the loan and you have to pay us back. But they don't typically enforce that as long as someone's paying. As long as someone's paying the mortgage, they don't care. So as long as the kids continue to pay the mortgage, there shouldn't be an issue. Yes. So the home will, the trustee is going, the home is in the name of the trust. When the person who created the trust passes away, the trustee is going to transfer title to the 2 beneficiaries, in this case, the 2 kids. Yes.
Okay. My mom is 99 years old. Okay.
So they have
We
it.
have a will. And I'm the only, my brother passed away and my sister. So do you recommend for me to go to the trust?
So let's talk about it. Each estate is different. I can't necessarily say your mom needs a trust. If your mother has a home, it's over $184,500. $184,500, which most homes in California are, right? Then I do believe a trust is probably best for her. When you were talking about someone at that age, you're also looking at capacity. Does she understand? Okay, so as long as she has capacity to create a trust, it would probably be in her best interest to do so.
Okay, you guys, we can go forever, right? I don't want to do that, too, she has, pamphlets that you guys can have, in contact with her, meet her. Okay, and also, like I said, for those who can't, it's not affordable for some people, that we do have to come about net law. Net law, NETLAW. They run around $600, no more than 1,000. Depends on some things too as well. So, Wanda, W-A-N-D-A. Walton? Yes, okay. We're gonna break for lunch, because I do want to leave at 12 o'clock.
Yes, ma'am.
And so, we have sandwiches in there for you guys. You guys can still be around and ask for questions to you. I'll be around and ask questions. Anybody want to know anything about life insurance last week, you could ask me questions or call me. Other than that, we're gonna go ahead and go forward with that now that, the prayer is out for lunch. Prayer of food.
On the microphone, please.
Before we pray, I just want to say thank you all for coming. Thanks Sandra, thanks Pastor for asking for this. I think it's been beneficial, and then maybe we can do it again.
Lord, we thank you for the information that we received today. We ask that you bless the food that we're about to receive in the name of Jesus. Amen.
You guys can go in that room right there, grab your lunch, have water, and have fun. Oh yeah, you guys came to the sanctuary because it's all on me when y'all leave, so I had to clean up before you guys come, so get all your papers and all that stuff.
All your little, ladies, women working on the word, we're starting a new book. Oh, don't forget the survey that's in your thing. It's for the second section. We have prizes still. We have prizes. First 5 people that turn in their survey get paid. Please complete your survey so we'll know how to make it better. The women working on the word, we meet every once a month. We met this morning. We're starting a new book. We're starting a new book in September. So please think about joining Women Working on the Word. We meet via Zoom, usually the 4th Saturday at 9, but we moved it. We have to move it sometimes because business meetings. So please consider, we just finished Discerning the Voice of God. Really good study. Consider joining us. Thank you. Bye.